Mr. Rishi Maraj, who hails from Trinidad and Tobago. He is a seasoned data protection advisor known for his exceptional expertise in safeguarding sensitive information and ensuring compliance in an evolving digital landscape. With an impressive career spanning more than a decade, Rishi has established himself as a trusted authority in data protection strategies, privacy regulations, and risk management. His meticulous approach to assessing vulnerabilities and designing comprehensive data protection frameworks has proven invaluable to a diverse range of organizations. Rishi's commitment to staying ahead of emerging threats and regulatory changes sets him apart, allowing him to offer tailored solutions that address the unique challenges faced by each client. As a dedicated advocate for data security, Rishi Maraj continues to shape the field of data protection by providing actionable insights and guidance that empowers businesses to protect their most valuable assets and data.
Thank you very much, Gabrielle, and good morning to everyone in Jamaica. It's afternoon time here by me, and I know it's morning time by you guys. So allow me to share my screen. And please let me know if you're seeing my screen. Yes, beautiful. So, good morning, guys, and thank you very much for day 3 of this very important webinar series hosted by ScanBox, M-Files, and myself from Privacy Advisory Services to really, get organizations to understand what is this creature known as the Jamaican Data Protection Act, to understand its impact on you as organizations, and to provide you with some strategies and technologies that you can use to allow your compliance journey to be a lot more easier than you think. It's not complex at all. It takes some time, but we're here just to make it easy for you to understand what you need to do. So let's get straight into it. What's the purpose of the JDPA? I think we all know in the world we live in today, we can't transact services without providing pieces of data on ourselves. Every time we go to a store or we interact online, we are always sharing pieces of information about ourselves, from our names, our addresses, our phone numbers, to even items that we click on different social media sites, on different shopping sites, all those kinds of data, which is known as metadata. And Sonia will talk a little bit on metadata and the importance of metadata. All those pieces of bits and bytes of information, when combined, gives a good idea of who we are as individuals. And organizations use this information for different purposes, to be able to tailor make services to us, to be able to understand what we may like or do in the future. But as we have seen also, this kind of information, this amalgamation of different pieces of information to understand who we are as individuals, can also be very dangerous. So because of this, Jamaica, like many countries in the world and countries in the region, have taken the step to develop and pass a piece of legislation that will provide some sort of protections and guidance for how companies treat with people's personal data. So that's where we have the Jamaican Data Protection Act. And I should mention that the Data Protection Act of Jamaica is based or modeled around the General Data Protection Regulation, or the GDPR, from the EU, which is considered by many as the gold standard of data protection laws in the world. It's modeled on it. Obviously, there are slight differences in the Jamaican context, but in essence, the Act is really, I would like to say, it's a rule book, and it's designed to ensure that personal information is handled with care and respect. It sets about standards, and I'll talk a little bit about the standards later on standards for how businesses and other entities should manage and protect our data, because at the end of the day, it's our data, it's your data as Jamaican citizens that companies are using to be able to generate goods and services and provide things for you and to understand who you are. But again, at the end of the day, it's your data. and what some of the main purposes of laws like the Jamaican Data Protection Act is really built on the idea of respect for privacy. And of course, we know in Jamaica, this concept of privacy of individuals is enshrined in the Jamaican Constitution. It sets about clear rules for organizations. In terms of your transparency now, you have to be a level of transparency with individuals, with how you collect and use and share their personal data. It gives individuals, all citizens of Jamaica now would have rights. And I'll touch a little bit later on in the presentation about what those rights are. But you now have rights that you can use to, question and clarify and understand what companies are doing with your data, and even have the ability to restrict sometimes how companies can use your data in certain ways. It holds organizations accountable. If organizations and companies don't follow these rules, there are stiff penalties that come out from the act. And again, a couple slides down, I'll touch a little bit on what those penalties are. So organizations need to take data protection seriously in terms of how you treat with people's personal data and understand what the act means for you, because there can be consequences, financial consequences that could impact you, and other consequences that I'll talk a little bit about later on. And then it creates a framework to allow for safe transfer of data outside of the country. A lot of companies are now using cloud service providers, using companies on softwares that are based externally, and for good business reason. It makes good business sense. It's a lot more economic, cost efficient to do these things. And the act does not restrict that, but it says that, so ideally it says that you shouldn't transfer data out of Jamaica. But if you do want to transfer data out of Jamaica and use cloud services, it sets guidelines that you need to be aware of in terms of how you treat with personal data and how you work with your vendors to ensure that you provide the same adequate level of protection to data that's transferred outside of Jamaica as if the data was still here within Jamaica. So again, these are just some of the key points about the act that I think every organization needs to understand how it's going to impact them. I mentioned previously the word standards. And what do I mean by standards? So the act uses certain jargon words. You will hear words such as data controller, data subject, data processor. A data controller basically is an organization that's responsible for collecting data. It sets about the parameters as to what data we need to collect, why we need to collect this data, and how we're going to use this data. So they're the main company or organization that's responsible for collecting and utilizing personal data. All companies that collect and utilize and process personal data would be considered data controllers under the act. So everyone here who's representing a company, once you collect information on individuals, regardless of if it's a client, if it's an employee, prospective employees, prospective clients, beneficiaries, or external data of individuals associated to clients, once you collect personal data on anybody, you have to comply with the standards of the act. And these are the standards. So the act sets about 8 standards that companies need to be aware of and follow these standards. Otherwise, there is possibility of fines by the regulator. So these standards, I'll touch on these a little bit in detail. The first one is personal data should be lawfully and fairly processed. So you have to have a valid business reason for collecting and using personal data in ways that doesn't negatively affect the person. So you need to have a proper understanding of what data we need to collect. We need to understand our processes to understand what data do we collect, why do we collect this data, do we really need this data, and it must be lawfully and fairly processed. And by lawfully, I mean you must have a lawful basis for collecting the data. And a couple lawful bases that exist for collecting data include, I've gotten the consent of the individual, but consent is not the only means. There are other ways that you can collect data besides consent. For example, if you have a contract, enter into a contract with somebody, if you have a law that says we have to collect this data, it's for the vital interest, life and death protection of the individual, you can process and collect the data. If it's for public purpose, so you're a public authority, then you obviously have a public purpose for collecting data. So you need to understand what the lawful purposes are that you can use to collect data and see where your collection and processing of the data fits into it. Second standard is purpose limitation. Data should be collected for a clear and specific purpose. So if we have collected data for purpose X, and after we've collected the data for purpose X, we've decided, you know what, we also want to use this data to do something else. You cannot. You need to now go back to the individual and get their consent or find a legal basis that you can utilize to justify using that data for another purpose from which you originally collected. So like I said, if you collected the information for a particular purpose and you now want to use it for something else, you now need to make sure that you have a proper legal basis. And if not, you need to go back and inform the person, inform the data subject and get their consent to be able to use their data for other purposes than you would have initially needed it for at the point of collection. Third standard is minimization. And all these standards, you realize, build upon each other. And what data minimization means is that we only collect data that is relevant and limited to what is necessary. We no longer should collect data because you feel that it may be useful in the future, but you need to focus on why you need it now and just collect what you need now. And there's good reasons for that. One main reason is once you collect data, data is now useful to organizations, but it's also a business risk because there are parties out there that will like to get access to your data for different purposes, you know, that are not legal and not kind, obviously. And the more data you collect, you may feel, okay, the more data we collect, the better. But it also puts you at higher risk because if that data becomes compromised, then it exposes that information to the world at large. And it exposes the information of your clients, your customers, your employees. So you need to limit your data to what is necessary for that specific purpose. And if you need to collect other data as it expands, then you now need to clarify and get the consent or again, get a proper legal basis for collecting additional information. Fourthly, information should be accurate. Obviously, we all know quality information and quality data is important for any organization. So you must take steps to ensure that the information you have is accurate and kept up to date as much as possible. The fifth standard is storage limitation, which is data retention. If you don't need the data anymore and there's no lawful basis to keep the data or no organizational basis to keep the data, then it's best you delete the data as best as possible to ensure that no one can access it anymore. In some cases, companies may say, okay, we may not need the data from a personalized perspective, but there are possibly data that we can use for research or for statistical analysis, trend analysis, or whatever it is that we want to do with the data. And in that case, what you can do is you can anonymize the data, take away the personalized part of it, and use the raw pieces of information. Then you can do that for sure. But again, you need to understand and have proper policies and procedures in place to ensure that you don't keep it for any longer than needed. Because again, it's a risk. These are risks that could come back to hurt organizations if it's kept for longer than is needed. As I mentioned, all Jamaicans have rights under the Act. And you should always make sure that you process personal data in accordance with what those rights are. And I'll talk about that a couple slides down. The seventh standard goes without saying. You need to make sure that you protect the data as best as possible. And I should mention here that when we mean and speak data, we don't just speak electronic data. We're talking about physical hard copy records also. So it doesn't matter if it's physical hard copy records or electronic data, the Data Protection Act applies to all of it once it collects or has personal data on it. And you need to make sure that you take the proper steps to secure it from an organizational perspective, as well as a technical perspective. The Act doesn't say what you need to do. Most of these laws are what we call technology neutral. So you need to understand your type of data, classify it, and then based on that, take the best requirements you think is necessary to protect the data. And then the eighth standard deals with transferring of data outside of Jamaica, which I touched on early on, and that you need to ensure you take the adequate measures to protect and put in place to apply with the Act if you need to transfer data outside of Jamaica. Apart from those requirements, there's some additional requirements that I think data controllers need to be aware of. One is registration. All data controllers need to register with the regulator under the Act, and it's under Section 16. For certain types of organizations that are public authorities, for example, or organizations that process sensitive data or data, personal data on a large scale, you may need to appoint a data protection officer. And that's, again, under Section 20 of the Act, which outlines the appointment of a data protection officer and the requirements of that. Again, if you do suffer security breaches that affect personal data, once you become aware of it, you now need to report that to the commissioner within 72 hours. So within 3 days of becoming aware of a security breach that affects personal data, you now have to have processes in place to collect, collate, document, and report to the regulator within 72 hours. And it outlines in the law what are some of the things you need to when you're reporting to the regulator. And you'll also need to report it to data subjects, so people who may have been affected by that breach. And then lastly, all organizations must conduct a DPIA, which is a risk assessment. And this must be done 3 months, 90 days after the end of the calendar year. So as of April 1st, 2024, companies will be required to submit a data protection impact assessment to the regulator. I would have talked about rights. All data subjects, all Jamaicans, everyone on this call, these are the rights that you have under the Act. And some of these rights include the right to information, the right to transparency, the right to get companies to let you know what data they collect on you, why they collect the data, what's the purpose for collecting the data. And this is normally done in a form called a privacy notice or a privacy statement. You have the right to access information from companies that they may have on you. You have the right to rectify or correct information that may be wrong. And if there's no longer a business need or a legal need for the company to keep it, you have the right to get that information deleted. You also have the right to prevent processing in certain activities, depending on what processing activities the company wants to do with your data. You have the right to object to direct marketing, and you also have the right in relation to automated decision-making to have a human element intervene and review decisions that may have been automated based on personal data organizations have on you. So again, these are the rights that all Jamaicans will have come December 1st, 2023. And companies need to be aware of this so that they have proper processes again and procedures in place to deal with these requests if they do come into organizations. Of course, as I mentioned previously, non-compliance with any law brings with it fines, and the JDPA is no different. Each particular area in the Act will outline certain different types of penalties depending on what you don't, if you don't comply with the Act, and those penalties can range between $1 million Jamaican to $5 million Jamaican dollars at times, and possibly even imprisonment depending on the offense. Businesses that don't comply with the Act also can be fined up to 4% of the annual gross worldwide turnover for the preceding year. And also under Section 68, directors and of businesses can also be held liable for non-compliance with the Act. Apart from that, there are other types of risks that companies can face for not complying with the Act, such as legal and litigation. Nothing stops individuals from taking legal action against companies for not complying with the Act. So apart from regulatory fines, you may also be faced with fines in terms of people taking you to court. So again, these are things that you need to be aware of. Reputational damage, once companies become breached and personal data is exposed, it has the ability to negatively impact the reputation of companies if they don't deal with it in a proper way and if they don't manage the communication channels properly. So there's also the possibility of reputational damage, operational disruptions in terms of certain things you may want to do with the data. A regulator may come and tell you, listen, this is not complying with the Act. This is a very risky operation, and we think that you should stop processing data in this format. And that could lead to business disruption depending on the type of processing you're going to be doing. And there's also the possibility of loss of competitive advantage because people are now using data protection as a way to differentiate themselves from their competitors. But there are also benefits. And some of these benefits I'll break down by different type of organizations depending on who you are. But there are some of them, they run straight across the board, whether you're financial, a small, medium enterprise, or even a public authority. And one is obviously trust. For me, data protection is always about trust. If I can't trust you with my data, then why should I do business with you? So compliance with it leads to trust and reputation that you are a company that people can trust and do business with, because you take seriously protecting people's personal data. And from a financial point of view, that includes very, sensitive kind of data like financial data. Benefits of a complying with the act is also it should form part of your overall risk mitigation approach within an organization, because again, it's about risk and dealing with data and understanding what's the significant impact it could have on organizations. So it could and should form part of your overall risk mitigation approach for any organization. Data protection program should always form part of your overall information governance and data management approach. And that way it can help improve operational efficiencies. And I know later on in this webinar, you will get some ideas as to how technology together with data protection embedded into it can help improve operational efficiencies of all organizations. For SMEs, it's about business growth. There are many countries in the region now, Barbados, Cayman Islands, Trinidad, that are now passing data protection laws. And most of these laws are all based on GDPR. So if you want to expand and grow your business beyond Jamaica, complying with the GDPR gives you the ability now to also go into other markets and be able to service those markets, because you now have a platform that you can build on, that we are able to now comply with the Barbados law, the Cayman law, whatever other laws are out there. So it gives us the ability to grow. It helps to avoid penalties, because while some large companies may have insurance and be able to avoid fines, most SMEs can't, and it can be very crippling to them in terms of these types of fines. And again, this whole question of reputation, it goes across the board. You need to enhance your reputation, and in a crowded marketplace, it can be a very useful selling point for all organizations going forward. Similarly, with the public sector, it's about trust. We all always ask the question, can I trust government with my data? We have the NIDS program in Jamaica and other similar initiatives throughout the Caribbean. And people are always asking, well, why does government want all this data? Can I trust you? So it's about engendering public trust in you as a public sector organization, making sure that you are transparent with people in terms of how you use your data. And it can also assist in interagency collaboration in terms of sharing of data about different agencies if there's a standard approach to data protection and data management within the public sector. So again, these are just some of the benefits that most organizations could get coming out of complying with the GDPR. So what does that mean for you come December 31st? So this is a very quick roadmap, and I'll spend a little time, not too much, but going into exactly what does this roadmap mean, how this can impact on you to be compliant by December 1st. So one is internal data protection governance. You need to have proper leadership, whether you're a small company or whether you're a large company. Having leadership for overseeing data protection within your organization is important. And having a proper governance system, roles, responsibilities is important for all organizations. So having that internal leadership that will lead the implementation of data protection in your organization is important. Two, as I mentioned, you need to register with the Office of the Information Commissioner. Section 16.2 will outline some of the information you need. So you now need to begin to collect and collate the information. Okay, it's a lot of information that you need to collect. So you need to begin to collect and collate that information to assist with the registration process when it begins, whenever the commissioner sets about the platform for you to be able to register. Three, appoint a DPO. You need to determine whether you need a DPO or you need an advisor. Some organizations may need a DPO, others may not need a DPO, but probably an advisor, somebody that they can rely on from time to time to get guidance on certain things. So you need to either appoint a DPO, or I would probably add here also, see if you need to get an advisor that you could probably have on a current monthly basis, so that's somebody that you can get guidance on when certain things come up, depending on the size of your organizations. Have proper documentation and policies and procedures. that will guide how you treat with people's personal data, because the act is now going to force companies to document certain things. Sometimes we just practice by, this is how we've always been doing things, and it's never been documented. You're now going to have to develop certain types of documentation and policies and procedures. Example relating to data protection policies, data retention policies, data sharing, etc. You would need to review your forms and your processes, because you need to now understand, how do we collect consent from individual? Is it bundled consent? Do we ask them to consent to 3 and 4 different things? That will also need to be looked at and reviewed and revised in the way you collect personal data and the way you collect consent from people, because again, you need to understand what the law says with regards to that. And, time is too short to go through all those things. But again, understanding how you collect it in your forms and processes and making reviews and adjustments to those. Vendor management, again, if you have external parties that you're going to be using to process, store, or assimilate your data and provide you with reports, whatever it may be, you need to review your vendor agreements, your vendor contracts. You need to have proper due diligence assessments and questionnaires to ensure that these vendors have proper things in place to manage data protection. You need to develop internal procedures, such as if we have data breaches, how do we collect the information from a cybersecurity point of view? How do we collect and collate the information from a data protection point of view to report to the regulator? If we get data subject requests, how do we deal with those requests? How do we deal with those complaints? What's the process we have to now use to go through this through the organization? 8, a data protection impact assessment is a risk assessment that you will have to submit by the 1st of April. So you need to now develop methodologies in place and get guidance in terms of how we go about completing a data protection impact assessment. And then 9, staff is very important. All members of staff need to be aware of data protection and the requirements of it on the organizations. You need to make sure and train your staff as much as possible and upskill them on what data protection means to the organization, how it's going to impact their work, and things that they need to be aware of. For example, if there's a breach or something comes in, what are some of the steps I need to take to report these breaches to the relevant people? Or how do I treat with complaints if people make requests? Again, these are all part of understanding and learning what needs to get done within the organization. So with all that being said, I thank you very much for your attention this morning. And I look forward to any questions that anyone may have coming out of this.